Good morning. So I'm going to try to cover data use agreements, at least the ones that are processed through our office. It's not a whole lot of information. I feel like that data use agreements can be very, we get a variety of them. There's a lot of different requirements, a lot of different things that are included in them. So data use agreements typically will come through the unfunded team of SRS to review and get approval. So I'm going to get started, and then if you guys have any questions at the end, you can let me know. I have contact information at the end, and you can always email me if you have any questions about data use agreements. So, just to cover what data is for our use, it's used in relation to research agreements. The data may include confidential, protected research project results or restricted use information. Some examples include records from governmental agencies or corporations, some student records, information, and human research subjects data, which could include protected health information and personally identifiable information. Those are typically the two types of human subjects data that we see being transferred that would definitely require a data use agreement, as well as some compliance involvement to ensure that the requirements in the agreement can be met so that we could store the data. So, PHI, which stands for Protected Health Information, it refers to any individually identifiable health information that is created, received, maintained, or transmitted by a covered entity under the Health Insurance Portability and Accountability Act. We typically There's a lot of entities out there that I think refer to the data as PHI when they are not technically a covered entity. In that situation, even if there are going to be strict requirements for that data, it's not necessarily considered PHI. So when you see PHI, it should include these types of information: medical records, health insurance information, demographic data, genetic information, payment information related to healthcare. HIPAA protects PHI by establishing standards for its use and disclosure. It ensures that individuals have control over their medical information and that it is handled confidentially. Like I said, if there is PHI being transferred, we only have just a few covered entities on the TAMU campus that are set up to store PHI. If it's an entity on campus that is not set up to store PHI, we definitely need to get the privacy office involved to review the agreement and what requirements there are so that we can ensure that anything transferred here can be stored appropriately and that we can meet any requirements that are needed to store that information. PII is a little bit different. So it's any data that can be used to identify a specific individual, either on its own or when combined with other information. So examples of PII would include names, addresses, social security numbers, driver's license numbers, and biometric data like fingerprints or facial images. This information must be protected to prevent harm, embarrassment, or unfairness to individuals. So this is just information that would identify an individual, but is not necessarily health related. So this would also require some, depending on what the agreement says or what requirements there are, it may require some pretty strict storage things to be implemented to make sure that we can meet those requirements of storage and then make sure that it would not be exposed at any time so that we can meet those requirements. So here are some of the things that would help you identify what PII is. So you have direct information that it directly identifies an individual. So it would have their name, their social security number, or a passport number. There are some other ways or things that might be included that if someone were to kind of try to backtrack and identify an individual, they may be able to do that. Those are indirect identifiers for this information. So it can be linked to trace an individual's identity, and those examples may include date of birth, place of birth, race, geographic indicators, employment information. So there are just a couple of reasons that we would put a data use agreement in place. If the data is not necessarily restricted, it doesn't necessarily mean that a data use agreement needs to be put in place. So the one reason that we typically see for putting a data use agreement in place is for our TAMU faculty members to utilize data from another entity. So for that data use, we would create an agreement between the data user, which is typically our organization, and the data provider, which is typically the outside organization. And we will include the provisions that are associated with the sharing of defined data. So depending on what type of data it is, we're going to include provisions in that agreement to cover the security and storage of that type of data. Usually, if we're the user, then the data belongs to another entity, and those agreements will come in, and we will just ensure that we can meet those requirements. The other purpose for the data use agreement would be a data transfer, where our TAMU faculty members are wanting to transfer data out. And typically, this is for if a faculty member is leaving or someone is wanting to move data from A&M to another entity. So we would create a data use agreement. Our current template that we use is can be utilized for both. It can be used for use and transfer. There's just a little bit different requirements in that agreement. And so we would actually be transferring the data from this organization to another organization, and there wouldn't be the return or the destruction or any of those requirements included in the data use agreement. We do typically, our office does not handle data purchases, but if there are data purchases that are done by our faculty members, then those would run through TAMU contracts as a procurement, and those would be handled a little bit differently. Some situations, if there are specific restricted requirements on the data, we may work directly with TAMU contracts to review those data use agreements and ensure, again, that compliance has been met and that the department that will be holding the data can meet the requirements within the data use agreement. But those will be handled by the TAMU contracts department rather than ours if there is money involved. Okay, so the purpose of the agreements. DTUAs address important issues such as limitations on use of the data, liability for harm arising from the use of the data, publication and privacy rights that are associated with transfers of confidential or protected data. The DTUA also assures that data users are using the data in accordance with the applicable law, like HIPAA or FERPA, and prevents the inappropriate use of protected or confidential data could cause harm to the investigator, the university, or individuals whose data is part of the data set. So we would usually only require a data use agreement when the data is not de-identified. So if it does include protected health information or personally identifiable information, those would be times where we would want to put a data use agreement in place. There are definitely some times when data is exchanged between entities and it is de-identified data, and there is not necessarily a requirement for a data use agreement, although it would never hurt to put one in place to ensure that the data is handled appropriately, that, publications or IP are mentioned. There's always the possibility of putting one in place anyway, just to ensure that we have those terms in the agreement. This is the information that we would need to address in the data use agreement. So what data will be released or shared would be included. Who has ownership of the data? What, if any, identifiers will be included in the data? The purposes for which the data may be used, whom, if anyone, the data may be shared, data security and safeguards, to whom violations of the agreement should be reported, the term of the agreement, the disposition of the data at the end of the agreement. And typically, if there is someone or another collaborator that data would be shared, a third party, we would want to include them either in the original agreement, or we would want to ensure that we put in place an additional agreement to cover any data transfer from that outside entity. So when we're completing the review of the data use agreements, depending on the type of data that is to be shared and the requirements that are that are in the agreement that are going to need to be followed by our faculty members for data storage or handling of the data, we may engage other compliance offices to ensure that they're aware of the data that's coming on campus and that they can ensure that the department that is taking the data in can meet the requirements within the agreement. So when there's human subjects involved, we will always pull in the institutional review board to ensure that there is an IRB protocol either in process or in place. A lot of times when a data use agreement with human subjects data transfer is being handled, the entity usually always asks for proof of the institutional review board protocol or exemption to ensure that it's being handled correctly on TAMU's side. So we will also engage the privacy office when the data includes restricted data such as protected health information and sometimes personally identifiable information, depending on what type of security requirements are involved. And a lot of times, the privacy office may also pull in the institutional review board or IT to ensure that we are meeting the requirements that are listed in the agreement and that the data is being stored appropriately and that there's a data management plan in place if needed and that they continually have correspondence and relationship with the principal investigator or faculty member that is handling that data to ensure that we consistently meet the requirements as long as the agreement is in place. If the data use agreement requires specific types of hardware, software, encryption, dissemination, or storage requirements, we are going to always ask for IT's input. And we're going to ensure that IT says that wherever this data is being stored, that we can meet the requirements and that they have put those things in place to prove that we can meet those requirements. Sometimes the data use agreements will ask for an IT representative to sign off on those, or they'll at least ask for a contact. And so we'll want to make sure that we include that information as well so that there's always a contact between the outside entity and IT to keep in correspondence during the duration of the agreement. So right now, for any data that is sent out from Texas A&M to an outside entity, we utilize the Federal Demonstration Partnership Data Transfer and Use Agreement. The template can be used for different types of data transfer. There is an FDP working group that is always trying to improve and update the template if needed. The great thing about this agreement is that you can actually go in and select the type of data that is being transferred. And based on the type of data that you select, the terms and conditions and requirements will change within the document so that we can ensure that the outside entity that we're sending the data to follows those requirements and we have those in place for whatever type of data is being utilized. There are some OGC approved data use agreements that we do utilize as well on occasion, depending on, if there's a different type of situation where we need to include data or the transfer, or sometimes we have transfers of data within the institution that includes protected health information. things like that, where we may utilize a different type of template, but this is the one that we will typically use for any, I would say, normal data transfer situations. This is what we would utilize. And we do receive any other outside entities. If we receive this FDP data transfer and use agreement, it makes the review a lot quicker because we know the terms that are in it. We know that we can meet the terms that are in it. And so when I receive these, the review is very quick. The turnaround time is very fast. So right now, any data transfer and use agreements received by outside organizations, they should be reviewed and approved by our group, or they should be reviewed and approved through TAMU Contract Administration, through AggieBuy. Currently, we do also receive the unfunded team at SRS will review any data use agreements that are part of funded sponsored research agreements. So they will actually get our input and review on those data use agreements that have been included in those research agreements. So they should definitely not be signed by a faculty member or a grad student or any others within the department. They should be reviewed by our office to ensure that the terms and conditions are ones that can be met by Texas A&M. So that's pretty much all I've got on data use agreements at the moment. So if you have data use agreements that come in from another entity that you need to be reviewed and signed off on, please send them to negotiations@tamu.edu, and then we'll ensure that they get reviewed and get to the proper compliance areas if needed and get those signed. If you have any questions in the meantime, you can always email me about questions of transfer data. If you have a data use agreement that's been sent to you and you have questions about it, you can always reach out to me.